This is Hidden Killers with Tony Bruschi.
Before a single opening statement in a courtroom, everyone is already pulling harder on the steering wheel than ever, either the prosecution or the defense. In the case against Bryan Kohberger, the judge isn't just keeping order, he's directing traffic. Whole swaths of evidence are getting clipped out. Words like murder, psychopath, and even the term touch DNA are being treated like they're radioactive. Meanwhile, evidence like the K-bar knife and the order from Amazon and DNA on the sheath are left at the scene. It's all in. Game on. It begs the question, what's more important in a trial like this, the evidence itself or the legal scaffolding that tells the jury what to even pay attention to? Joining us is someone who knows the rules, has enforced them, and has even worked with evidence that can make or break a federal case. Jennifer Coffindaffer, retired FBI special agent, host of the Break the Case podcast. She's here. Let's not, tiptoe at this. When you see a judge toss out words like psychopath and clamp down on forensic lingo while allowing the heavily curated Amazon history in, what's your first instinct here? Is this all on track? Is the judge doing a good job thus far into the case, or is he boxing things in a bit too much? Where do you stand?
I think that Judge Hippler is doing a great job. I don't think you should be able to say psychopath, and there was another word. He's actually allowing murder and murder.
Yeah.
Because you should be. It's a murder trial.
Mm-hmm. Yes.
But he got rid of the psychopath, sociopath. Those are out. And I think, in my opinion, the biggest mistake so far, succinctly regarding the trial, has been made by Ann Taylor. And that was to ask for touch DNA, trace DNA, contact DNA. Those three words cannot be said by any DNA expert on their side or the other side.
Mm-hmm.
And because guess what, Tony? Now they get to use the word DNA. And that is so much stronger than touch, trace, or contact. So in my opinion, she did not foresee what that meant, asking that. And so now they get to say DNA. DNA was there. And the jury is going to hear that much stronger than trace DNA. That's my opinion.
That to me is like a shocking error, if that's what that was on her part. Was she thinking that, okay, if we get rid of touch, trace, and contact DNA, that the whole word DNA is just not going to be allowed in, and she just failed to mention DNA in general? Because that to me is, I don't know. I mean, I'm not an attorney, but I look at that and go, yeah, those sound a lot more confusing and a lot less powerful than just DNA.
No, I agree. I think what happened is obviously they're going to be able to discuss it.
Mm-hmm.
They're going to be able to say it wasn't from hair, blood, or semen.
Yeah.
They're going to say but they can't say, like I said, contact, touch, or trace.
Mm-hmm.
So they're going to be able to explain it, but still the jury is going to hear probably hundreds of times DNA.
Mm-hmm.
And I think she made a big mistake. I wouldn't have touched that with a 10-foot pole. It's in her expert's report. It's in the prosecution's expert's report because it's a specific kind of DNA.
Yeah.
Just like blood. Blood is not DNA. DNA is in blood and in hair and in semen, right? So to be able to describe where the DNA was located is critical, and she took that component out.
It makes me wonder a little bit because she's a pretty competent attorney. I mean, she's arguing like every possible thing she could possibly argue in this case, even if it's somewhat ridiculous. But I'm wondering how much Kohberger is doing an influence on this, where I wonder how much of an idea that was his, saying, I want that out. That should not be in there because it's going to make people think this. And because his thinking is a bit skewed and not necessarily in line with the rest of the world, if that's one of his ideas and she's doing, what the client is asking.
I see him, and I don't know, but I see that his role would probably be more of like a research assistant, that she has him pouring through everything, looking for little nuggets. Certainly, I think he's very involved in his defense, but Ann Taylor is a very strong personality. She's a strong advocate. I think she's done a good job from the standpoint of that strength. I think, the fact that she just throws everything up against the wall, Tony, I think it tends to diminish those important items she goes for. In other words, when you start just seeing everything's being challenged, it just loses, I think, the punch that it would have had if she just would have focused on the more important details.
The fact that she is going after literally everything, what does that tell you about the integrity of their case?
They have no case. They're throwing up prayers. They don't have the facts working for them, Tony. And when you have a case that you just are at a huge factual deficit, what are you going to do other than just send Hail Mary after Hail Mary and hopefully, somebody catches it. But it's rough for them. And now the eyebrows are in too. And that is another biggie.
Yeah.
They tried to get Dylan Mortensen's testimony about the bushy eyebrows out because now they have that picture 10:30 in the morning right after the crimes were committed of those huge bushy eyebrows. And, we all commented the first time we saw him in court, geez, they are manicuring those down. I should say when we saw him in court with a suit on, his hair gelled and looking good, him all manicured, and those eyebrows went from big caterpillars to little ones.
Yeah, that photo, that selfie, maybe one of his biggest regrets, I would think, maybe at this point in time. And in the far cry that he's innocent, even more so, if that would be the case, because it does not look good in any way, shape, or form. Let's talk about the K-bar knife a little bit. Obviously, he purchased that well before the crimes actually took place. It arrived to his parents' home out in Pennsylvania, and then obviously would have traveled back with him to Idaho and to Washington. We got that. Obviously, it doesn't look good that you bought the exact type of weapon and sheath and sharpener that was used to commit a crime. It doesn't necessarily mean that it's the exact one. People do buy these things all the time. But it's not so much the purchase that is going to be strong here. It's the click history, because it's not just, okay, I bought this. It's what are you looking at? How often are you looking at it? How damning is that going to be now that we know his history of looking at it before the crime, but also after the crime?
Right. That's the big thing. A couple of things there. So first of all, the defense is trying to say, listen, anybody could have bought that and had it shipped to them at their household. But the problem is it's going to, I think, from what I've seen from the documents, they're going to have the credit card information and they're going to have the click history on his computer that matches up with the orders. So there's going to be no doubt it's him, number one. Number two, you're exactly right. After the murders, he was looking for a replacement K-bar. Like most of us, not most of us, many of us have been saying from day one, if he committed this crime, our belief is this was just the beginning. This is somebody who truly was capable of being a serial killer and mentally. And then the fact that he bought it early, again, back to what many of us have said, and that is he planned this, dreamed about it, thought about it, and, in his mind played it out so many times. So I'm not surprised at all that it was well in advance. Way
back, because I think 9 months is as far back as we know about purchases go between the mask where you could see his eyebrows and the K-bar knife and such. Do you think all that way back he had his targets in mind, or was it more of a fantasy at that moment and he knew he was going to eventually hone in on someone to execute this sick fantasy of his, allegedly?
I think B, your latter explanation, he had an idea of what they would look like. He had an idea of what they would be like, act like, the person that they could never be with, the person that represented all he wasn't. And once he put his eyes on that and made his target, he was ready.
Let's talk about some of the cell tower data. Obviously, they say they have their guy that's going to say that, well, this shows he was nowhere near the crime scene, based on his interpretation of cell tower data. But the problem is between 2:54 a.m. and 4:48 a.m., his phone wasn't on. So no one has that data. All we have is where it came back on, where he was going initially, where he left, or where he picked up from, which showed he was leaving the general area. How are they going to argue that? How are they going to go and say, okay, this geodata that you have somehow supersedes the experts that we have that are showing us, no, I mean, look, he's been kind of surveilling the house. It goes dark. He could have gone anywhere at that point in time. And when it picks back up, it shows he's leaving the general area. That just, I mean, it does not seem like a strong argument at all, but they don't really seem to have a whole lot of arguments to go with here.
Well, the two big pieces that really came forward very recently, one of them very recently, was that phone was physically turned off. Mm-hmm. Remember, initially the defense was sort of saying, oh, they don't have cell phone towers out there, blah, blah, blah. It just lost signal, right? Mm-hmm. Well, now we know, at least according to the latest documents, no, it was physically turned off and turned back on. That, to me, the jury is just going to eat that up, Tony. I think jurors are so smart. I really do. Maybe I've just had such great luck with every jury trial that I've been involved with. I mean, they see it. Mm-hmm. They really do most of the time. You can't pull the wool over their eyes. Mm-hmm. And they're going to see that. Oh, my gosh, you turned it off right before the crimes were committed and then turned it back on right after?
Yeah.
I think it's really, really compelling. But as far as what do you do when you have one expert saying this and the other expert saying that? Well, I will say in a lot of trials, when you talk to the jurors afterwards, the experts, for them, just negate one another, and it kind of becomes white noise in the background. Considering all the money that is paid for these experts, lawyers might not want to hear that. But if you don't have one to counter the other, then it looks like you're just capitulating the argument. So you have to have it. Mm-hmm. But in my experience, typically the jurors are like, yeah, this one's paid by the defense. This one's hired by the prosecution. They negate each other. They're both going to say what they were paid to do. All right, let's move on to the facts.
And people can connect the dots. AT&T timing advanced records. That's a new phrase that's been introduced into this. The timing advanced records, it's another level of cell tower data that the defense is saying was hid from them, that the prosecution never turned it over. It's something they keep arguing in court. We didn't get this. The prosecution says, we didn't ever have it. So how are we going to give it to you? AT&T even saying, yeah, we didn't give it to you because we didn't have it. It only lasts for 7 days. And by the time you requested your data, it was many weeks later. And we don't keep that data that long. How long are they going to argue that? I mean, is that just a pretrial argument? Is that something that they can end up bringing up in court and try and say, look, this evidence was hidden from us, and who knows what that says because we didn't get it. But at the end of the day, well, it existed for 7 days, but no one knew to look at it.
No, I think that could be brought up, particularly when they have the AT&T person that produced the records on. I don't think they're going to stipulate. Oftentimes you just stipulate. I think that the defense could ask for them to come on and talk about how we didn't get it wasn't mentioned in the subpoena. And that was just a mistake, an oversight by in this case, the FBI agent likely that was tutoring the Moscow individuals. Remember, those people were sorely underexperienced. I think 2 years in, Payne had around 2 years, never done a murder investigation that I recall. In any event, he has said, his mentor was an FBI agent. So whoever designed those subpoenas, and I remember toiling over all my subpoenas, especially when it involved technical data, going through them. Do I have everything? And then sending it to my cyber folks, to my digital cell experts on the cyber squad, tell me, am I missing anything? Because you don't want to leave out just what happened there, a term that you're not aware of. And they're all over the place, depending on who you're subpoenaing, right? You can't know everything as an agent, so you go to the experts. So obviously one of these terms was missed. But so I think that the jury could look at that as long as they don't think it was intentional. I don't think it was a big problem. And then they'll get their expert to explain how that information does not, somehow erase the information it has. It just would have enhanced.
It's almost like the defense, if they bring it up, they're going to try and pitch it. It's basically adding confusion by omission. We don't have this, so what does it mean that we don't have this? Well, nobody has it. I think it could have been a boon to the prosecution, honestly, more than anything, if they had it, because it would likely put him where he was or allegedly was. But if there's confusion and we just don't know, then that adds the element of, well, he could have been anywhere. Well, in theory, but everything else points to that he was there. The autism argument, the judge says that autism can't be used as an aggravating factor in this. The state can only bring it up if the defense does it first. How do you think that's going to play? Do you think that the defense is going to try and bring autism into this? And is that going to be seen by a jury as part of a motive or mitigation in this? People can take that either way, I think. And one may look at it and going, oh, well, that means you're a little more prone to do this if he's on the spectrum area where there's lack of empathy and remorse, which is what he's flat out said he feels. And allegedly, if those writings of his online are true and truly his, or it can be looked at in the exact opposite way. How do you think that will play? And is it something that would be wise for the defense to even throw out there?
First of all, this is one of those examples where I think Ann Taylor just was really reaching beyond what she needed to do. And this is why I say that. I don't think the prosecution is going to want to bring up his autism. First of all, when I hear somebody is on the spectrum, to me, and again, I have a brother, I absolutely look at it even more empathetically, right? Oh, they might have challenges socially, but then anybody who's educated about autism knows that autistic people are no different than, somebody without autism in terms of being more murderous and more inclined to kill somebody or anything like that. I don't think the prosecution had any intention of bringing up autism. I don't even know if the prosecution believes he's autistic. Just because one doctor has recently come out. I think the defense will use it. And remember, the judge didn't fully rule on this. I could see the defense using it to mitigate down the road if he's convicted, to try and mitigate a possible death sentence. So I see them why they, brought up this new finding. I truly don't understand why they thought the prosecution was going to use it. I just don't see prosecution going in that direction, and now they won't be going in that direction because the judge says no.
Do you think we're going to see anything more psychologically about him? Are we going to? Can the defense, of him order some sort of psych eval? Can the prosecution order some sort of psych eval? Would either side want to order some sort of psych eval on him? Or the cards they're playing with right now, is it just a good idea to stick with what you have and hope for the best and not try to add something else into this mix?
Oh, I think those evals, in fact, we know now because of some motions we've seen that those have been done, and that the judge, he allowed it to come out that all of that was out there. Not that we're going to get to see the evaluations, but rather that they were done and are out there. And so the prosecution, I think, if they could use all the information about how he spoke in his writings about the visual snow and lack of empathy, how horribly he treated his father, just all that information to show he was just a ticking time bomb of a person. I think it could really help the prosecution. But I don't know if it'll come in unless the defense really opens that door to try to blame mental issues for his actions. This is, to me, going to be one of the most interesting parts of this trial. I think the prosecution initially will just want to focus on the facts and not muddle it down with that. But, juries want to understand motives. Why is this PhD student wanting to murder when he hasn't done anything except for stole a cell phone and had a few motor vehicle violations?
Yeah. And that's what I'm wondering about. I mean, I'm wondering, if more so not during the actual trial itself, but more so in the sentencing phase, if he's found guilty, if the defense will try to look back to those blog posts where he talks about visual snow, because I think that might give the jury a little more empathy, honestly, towards him. They can say, look, he's been suffering from feeling this way for all of his life, or most of his adult life. And, this is someone who's not well, and, spare him that. He couldn't control that part of his life, but lock him away, but let's not kill him because basically, he's an injured duck on the side of the road. Do you think that they would try and bring it up there? Because if you do that too, you can also probably bring up Papa Rogers if they can prove that, or anything else that digitally connects him. And most importantly, the damn photo with the eyebrows the next day with the thumbs up, because that right there, I think, is what could get him shot by a firing squad.
Yeah, no, I love all your points. If I'm the defense, I'm going to do just what you said. I am really going to try to paint him as somebody who didn't have a chance since he was a young teen. He was 130 pounds overweight. He had a heroin addiction. He, struggled to be accepted. Had visual snow, blah, blah. That is what and I don't mean the blah, blah, et cetera, I should say. But all that prosecution has to point out to me, I would put up 5 pictures. I would put up a picture of Maddie, Kaylee, Xana, and Ethan slaughtered, because that's what it's going to look like. And then I would put that picture of the thumbs up.
Yeah.
And I'd say, for these victims, you have to do, he didn't care about any childhood trauma they had.
No.
Xana's mother was a drug addict. Xana was abandoned by her mother. Maddie had some, home issues, blah, blah, blah. No, that does not excuse this. That's what I would say if I was the prosecutor. And I can't imagine. I just think a lot of jurors that picture might do it.
I do too. I think when I saw that, if it's him, that is the nail in the coffin.
If true crime is your obsession, we've got you covered. Press subscribe now to the Hidden Killers podcast and True Crime Today for non-stop coverage, expert insights, and in-depth analysis.